Welcome to the Great American Mail segment. This is a new segment for us, the biggest story of the day. We do a daily podcast. We'll put a link to it in the description. We do a daily podcast, and in the daily podcast, we do the various news stories of the day. This is a new segment. We're going to try to do it daily. I can't promise that, but we're going to try to do it daily. And we're going to cover what we think was the biggest story of the day. I'm going to do it a little bit different today. Yesterday, we did our first week in review. We're going to continue to do the week in review. We're normally going to drop it on Saturday. Unfortunately, though, we got a copyright complaint, so I don't think I violated copyright. We're going to have to check through that and make sure we didn't violate copyright. But anyway, so today we're going to cover what is the biggest story of the day. We would appreciate it if you'll subscribe. It'll help us because the more subscribers you get, the more features you're able to use. And so as a beginning channel, we only have the basic features. So to us, the biggest story of the day was Jennifer Rubin's article in the Washington Post describing the formation of 65 Project. What is 65 Project and why should you care? And why is it the biggest story of the day when Ukraine and Russia are in the news? Well, like everybody else, we spent, I think, of our 50 minutes of time in the podcast, we spent 40 minutes of it, probably a huge majority, talking about Ukraine, Russia. But I don't really think that was the biggest story of the day. The biggest story of the day was 65 Project. What is 65 Project? Well, it's a project of a bunch of partisan Democrats that have gotten together, and they are going to go after the law licenses of all of the lawyers that participated in any of Trump's lawsuits or any other things that they might have tried to do to challenge the 2020 election. Now, why is it called 65 Project? Well, because Trump filed 65 lawsuits, none of which, as you know, were successful. So Jennifer Rubin extolled the virtues of this and said this was a great thing. This is not a great thing, and we're going to walk you through why it's not a great thing in great detail. But right off the bat, it should not be surprising that something like this is not a good thing. Lawyers are out there to file lawsuits primarily, and you can't put a responsibility on a lawyer to only file a lawsuit that they think is going to win. Now, of course, as a lawyer, you're not allowed to file a lawsuit which is frivolous, but obviously, as it should be plain to anybody who is an attorney, and I am an attorney, I'm barred in 2 states. I've been practicing since originally in about 25 years in September, I guess. So here's the thing you have to understand, and it should be basic knowledge to most Americans, but potentially it's not. You, don't have to look behind whatever it is your client wants you to do. There are some situations where you may have to verify your client's information, but those are very, very far and few between. You're permitted to take your client's word for certain things. The second thing, and this is perhaps the most important thing that debunks the whole idea of the 65 Project, is the idea of a safe harbor. So even if the law is against you, so let's just say hypothetically, not one of Trump's 65 lawsuits had any merit to them at all. Let's just assume that for the sake of the argument. I don't believe that to be the case. I think a lot of and we're going to cover that in a moment, I think a lot of the lawsuits did have some merit to them, and we're going to discuss why they didn't go forward in a moment. But before you even understand that, what this 65 Project and Jennifer Rubin by extension are suggesting is that you can never challenge the law. Now, that ought to strike you as odd. The reason it ought to strike you as odd is that it isn't the law in America and never has been, nor should it be. So by way of example, Thurgood Marshall challenged the law that separate but equal was constitutional. He went to court in Brown versus Board of Education and sued and said that black children should be able to go to white schools. Now, it had been in the law of the land for approximately 100 years because of Plessy versus Ferguson that separate but equal was the law of the land. That was, in some senses, a frivolous lawsuit because for 100 years you have been able to separate people based on race. Now, what Jennifer Rubin and 65 Project and these Democrats are suggesting is that Thurgood Marshall, who later, of course, as you know, went on to be nominated to the Supreme Court by President Johnson, should be disbarred because he filed what was a frivolous lawsuit. Well, of course that's not the case, and you know that. And I could go through many other times where that's been the case. So you should know, first and foremost, there's such a thing as a safe harbor. What is a safe harbor? A safe harbor is a lawyer may file a lawsuit if he or she is engaged in a good faith effort to overturn existing law. So all of the lawyers that were participating in the various lawsuits that were filed by President Trump after the aftermath of the election of 2020, obviously could argue that they were filing to change existing law. Well, they don't need to do that because there wasn't anything wrong with the lawsuits that they filed. None of them, to my knowledge, has been found to be frivolous. And just so you understand how that works, if you file a lawsuit, and I'm only barred in 2 states, but I've practiced in various other states via Pro Hac Vici provisions, and I'm very familiar, I practice quite a bit in the federal laws. In the federal law, there is a Rule 11. And under Rule 11, you can file a claim against someone and try to have the court declare the lawsuit to be frivolous. That was not done in any of those cases. Similarly, to my knowledge, nobody ever found anything had been done frivolously and made that as a ruling of the court. In fact, of the 65 lawsuits, almost all of them were kicked out on standing grounds. What are standing grounds? Well, standing is a doctrine where the courts first to try to determine, are you one of the persons that should be permitted to bring this lawsuit? Do you, quote unquote, have standing? So by way of example, so you understand that, let's say I'm sitting here and outside of my house, I see somebody get hit by a car and I see them get injured and they decide they don't want to file a lawsuit. And I say, you know what, I saw that happen. That's not good for me. That's not good for society. It's not good for the citizens of Atlanta. So I file a lawsuit against the driver. I somehow find the information. I go into court. The court's going to say, I'm sorry, Great American Mail, you lack standing. You don't have the standing to bring this case. It's a case, but the only person that has standing are the person that got hit or potentially the immediate family, depending on certain circumstances. You, however, as a concerned citizen, do not have standing. So that wouldn't mean there wouldn't be any merit to the lawsuit. There would be merit to the lawsuit. I'm just not the proper person to bring it. And we'll come to that when we finish off the news of the day at the end, because there's a quick case that will bring that point to you. Anyway, so what are they really trying to do here? What they're trying to do here is, again, and this is just plain fascism, and I don't know why, but Trump seems to bring it out in these people, and this is what's going on. You're trying to punish political dissent. And that's basically all of the, again, another tell should be, they could have named themselves Project 20 or Project 15, right? Or 15 Project or 20 Project. I mean, well, we're not going to say all of the lawsuits were frivolous, just most of them or abundance of them. We're not going to say all of them were frivolous. No. That's the tell too. Every single solitary lawsuit was frivolous, which means you're never allowed to challenge elections in this country. That's not the Constitution. It's not the law of the land. And they go through in the article and they talk about they're going to go after all these various lawyers. The bigger problem here is that it's an attack not just on presidential elections to keep people from challenging elections, but it's also an attack on the rule of law, right? So now we're trying to go after the very people who would help you bring a lawsuit by saying, if you bring a lawsuit that we politically disagree with, we're not only going to try to get, and there's another thing too, there's a frivolous lawsuit filed, most places, most jurisdictions provide that if you can prove that, you can not only get the lawsuit dismissed, but you can get attorney's fees. So that's how we handle that. You don't need to take somebody's law license. This is all designed for harassment, and they well know it. Anyway, the other concern that's going on here, and this is just something that is difficult to address, because as we've seen after 2020, we've not been able to get any audit. We've not been able to get any lawsuit past the standing phase. Why is that significant? Because the way lawsuits work is you file a lawsuit. First, you have to have standing. Most of the cases, they never got past that, so the case was kicked out. In the few cases they did get past standing, you have a very limited remedy. And the remedy is often not what you think. You would think if I challenge an election, I'm sitting here in Fulton County, if I were to challenge the Fulton County election as a concerned citizen, first I probably wouldn't have standing, right? Because I wasn't running, I was only a voter. But let's assume I got past that. And I say, okay, here's my remedy. I would like to go through the entire voting roll. I'd like to look at every ballot. I don't want to see how the people voted or anything like that. We'll have an independent review. And then I want to see how everybody voted, and I want to check the tabulation. That's not what happened. In most of all of these cases, if you can get past standing, which more often than not you cannot, you get to ask the particular voting precinct or county or what have you, whatever the entity is, did you conduct a fair election? And that entity will come back to you and say, yes, in fact, we did conduct a fair election. Well, that's not what people want and not what people think. You should be able to get an audit. Another thing people don't understand is you should be able to get discovery. How can I prove whether there was fraud or not fraud if I can't get my hands on all of the different ballots? Right. So anyway, the last thing in this article that she goes through is, and this is definitely the biggest tell in here, that this project is nothing more than just a political fight going after their enemies, is they raise in here the lawsuit of Texas versus Pennsylvania. Now, you may remember Texas versus Pennsylvania. That was the lawsuit where the state of Texas sued the state of Pennsylvania and said thousands, actually hundreds of thousands of ballots shouldn't be counted. Now, why did they say that? They said that they shouldn't be counted because, as you know, the Constitution provides that only the legislature can direct how elections are to be held. Well, in Pennsylvania, we know because of COVID, the governor of Pennsylvania, a Democrat, decided that he was going to allow mail-in voting, something that was not permitted by the legislature before the election began. When he allowed mail-in voting to happen, a lot of people voted by mail. Now, again, I'm not blaming the people that voted. They followed the law as it existed at that time. Now, the Pennsylvania Supreme Court wouldn't do anything, wouldn't help Trump, because they are basically Democrats, and they didn't mind the fact that they think mail-in voting is a good idea. Anyway, you never got to, that challenge never really got well developed in Pennsylvania because the Pennsylvania Supreme Court is Democrat and partisanly so. So what some people decided to do, and you had, again, probably 8 senators, you had over 100 Congress people, got together. Ken Paxton, the Attorney General of the state of Texas, decided to file a lawsuit against the state of Pennsylvania. Now, the state of Pennsylvania, because it's a state versus state, you don't have to get certiorari to get to the Supreme Court. You go directly to the Supreme Court, because state versus state is one of the few things that the Supreme Court has original jurisdiction. So they went and they had original jurisdiction, and I think they had approximately 30 attorney generals as well. So this was a lawsuit that a lot of people signed on to, right? Members, tons of members of the House of Representatives, senators, attorneys generals. You had a lot of people behind this lawsuit basically saying, listen, I'm challenging the electors that came out of Pennsylvania because they were not cast, that election was not cast in a constitutionally provided provision, in that the governor changed the election law, and you can't do that. Well, the Supreme Court conveniently ruled, as I said earlier, here's a copy of you can see here, a copy of the decision of the Supreme Court. This was the court deciding they wouldn't take it, and it ruled this way. The state of Texas's motion for leave to file a bill of complaint is denied for lack of standing under Article 3 of the Constitution. Texas has not demonstrated a judicially cognizable interest in the manner in which another state conducts its elections. All other pending motions are moot. Now, we'll get on to Alito and Thomas in a moment, but I want you to understand that, as I said, we're not even going to let you proceed. You do not get discovery. You do not get to look into how the election rules were changed. You do not get to look into anything. We hereby say that you have no standing. Now, I don't understand how this works, because the Electoral College is the place where the states go and conduct their elections, right? In the election of president, he is the president of the United States. So the 50 states, through the Electoral College, have an election. Now, we vote about how those electors go, but this is a state's election. So you're telling me that as a state, Texas, or any other state, that I don't have a say, I don't have an interest to sue how another state does it. So even though the Constitution is, the legislature shall provide the rules for voting in a presidential election, what if, say, Georgia, I'm broadcasting from Georgia, what if Georgia says, you know what, we're just not even going to let the citizens vote at all. We're just going to do it the old-fashioned way. We're going to have the parties in a back room with cigars and whiskey, and they're just going to pick who they want to vote for election. What if they do that? Are you telling me no state has standing to even bring a lawsuit and say, no, the legislature has to set up the mechanism for how things are voting? It makes no sense. The ruling made no sense. Like a lot of these lawsuits, people just didn't want to touch it. It was a hot potato. Now, you may not like Trump. I don't care how you feel about Trump. This is the rule of law we're talking about here. This is not a good thing. So here's reading down a little bit, the statement of Alito. So Alito filed a separate statement of Justice Alito, with whom Justice Thomas joined. So that means they jointly feel this way. In my view, we do not have discretion to deny the filing of a bill of complaint in a case that falls within our original jurisdiction. He cites Arizona versus California. I would therefore grant the show. I can't read this. What? Come on. Anyway, I can't read the rest of it because I'm being blocked here. But I wish you would stop doing that. There we go. All right, sorry. I would therefore grant the motion to file the bill of complaint, but would not grant other relief. I express no view on other issues. So what he's saying there, sorry about that technical difficulty there, as we're new to this process. What he's saying there is basically we would let them file the complaint. What the others had said is you don't lack standing. So the ruling of the court was 7-2. You lack standing. You can't believe a case at all. Now again, what they're doing with 65 Project is far beyond that. They're basically saying that if you try and advocate for your client, if you get kicked out on standing grounds, which mostly they were, in the few cases that went forward, they didn't get far. To my knowledge, nobody really got to discovery to look into the evidence. They're now going to go after your law license. Now, this is nothing other than just going after your political opponents. But a bigger problem is it's also trying to negatively impact the rule of law. And they have a lot of Democrat firepower behind them, including a former senator, the first woman who served as the president of the American Bar Association, a lot of other heavy hitters behind them. This, to me, was by far the biggest story of the day. We'll see how it resonates as it goes throughout the week. Typically what happens is somebody in the Washington Post puts something like out there, and then people just parrot it around. Right now, you may not have heard of it, but you soon will. People will be talking about this type of thing, and it should scare you, because it's in the era since Trump. It really, the biggest problem is that they're not only attacking Trump, but they're basically attacking political dissent and the rule of law. We can't have different rules for different people. And if Trump's not somebody you care about, well, sooner or later, these people will get to somebody that you care about. So anyway, I hope you enjoyed this. If you did, subscribe. And like I say, we'll put a link to our daily show if you want to check that out. And we should be doing these on a daily basis. So check back in. And if anything was wrong, if I get something in the comment, we'll try and repair it next time. So hope to see you next time, potentially, hopefully tomorrow, on the biggest story of the day.